All right, all. I want to welcome you to our first event of the 2021-2022 academic year. My name is Jamie Rowan. I'm an associate professor of legal studies and political science at the University of Massachusetts Amherst and the director of our new center. The goal of this center is to many things, but to bring in scholars both locally and now, given the virtual platform, across the country to provide insights into important policy issues affecting justice and that are related to law and that can benefit the variety of societies we have around the world. I can't think of there's many topics we could be discussing and will be discussing throughout the year, but there was an urgency with the Supreme Court decision not to block the effects of SB 8 in Texas. It felt like an opportunity to bring people together into community for a discussion about the origins of this law, its ramifications, and for people who have questions to be able to talk to some of the leading scholars in the country on issues related to reproductive justice and constitutional rights. I'm extremely grateful for the opportunity to bring Professors Carrie Baker, Krystale Littlejohn, Cora Fernandez Anderson, and Joshua Wilson together on this event. What I'm going to do for this event is introduce them before they speak. Some of you have seen their bios, but what I can do to make sure that we're just going in order and we don't forget who they are, I will introduce them before they speak. So the first thing that I want to do is introduce Professor Carrie Baker. She will be our first speaker. Professor Baker is a remarkable scholar right here in the Five College community. She is a professor. I'm trying to get your bio up right in front of me because I'm getting all of these registrants that are taking away the link that I had to you. She is a professor at Smith College. She is the Sylvia Dlugash Bauman Chair of American Studies and a professor in the program for the study of women and gender. Her scholarship and teaching centers on women's rights law and policy in the United States, focusing in particular on sexual harassment, sex trafficking, and reproductive justice. She is a regular writer and contributing editor at Ms. Magazine, where she serves as co-chair of the Ms. Committee of Scholars and just some editorializing. Her columns are excellent. And so if you want just regular updates on things affecting women and reproductive justice and rights, follow her. She also has a monthly column in Northampton's Daily Hampshire Gazette, very active in our local community, and she is going to start our panel. I hand it over to you, Professor Baker. Thank you for joining us.
Thank you so much, Jamie. It's wonderful to be here, and it's thrilling to see so many familiar faces out there on the Zoom. So I'm going to lay the groundwork in talking a little bit about what SB 8 does, how it is enforced purportedly according to the law, what courts have done so far, what the impact of the law is, and how the law is being challenged. So somehow I'm going to try to do that in 10 minutes. I probably won't get all the way through it, but I wanted to just lay some groundwork. So the Texas law bans abortion at 6 weeks of pregnancy, which is around 4 weeks after fertilization and 2 weeks after a missed period if you menstruate regularly, which many women, transgender men, and non-binary people who menstruate do not. At 4 weeks after fertilization, an embryo develops a group of cells that gain the capacity to fire electrical signals, which Dr. Seema Aftab describes as a little flutter in the area that will become the future heart. Aftab is the medical director at the Fetal Care Center at Nicklaus Children's Hospital in Miami. This electrical signal can only be detected by a highly sensitive ultrasound device and actually exists before it can be detected by an ultrasound. So it's pretty arbitrary, this 4-week number. The former head of ACOG, Dr. Ted Anderson, has argued that the language of fetal heartbeat is inaccurate. So this bill is called a fetal heartbeat bill. And the idea is that the fetal heartbeat starts at 6 weeks, and that's why they're banning it at this stage. What Dr. Anderson says is what is interpreted as a heartbeat in the bill is actually electrically induced flickering of a portion of the fetal tissue that will become the heart as the embryo develops. Thus, ACOG does not use the term heartbeat to describe these legislative bans on abortion because it's misleading language, out of step with the anatomical and clinical realities of this stage of pregnancy. There's no heart at this stage and there's no heartbeat. And actually, it's not even called a fetus until 11 weeks. It's called an embryo. This ban affects 85 to 90% of abortion in Texas. Most abortions happen after 6 weeks, in part because of all the burdensome regulations in Texas that have been placed on access, which has closed down many clinics, subjected patients to waiting periods, raised the cost of abortion, which ends up in delaying access, and has required patients to travel long distances to reach providers. As a result, SB 8 bans virtually all abortions, and there's no exception for rape or incest or fetal anomaly, even fetal death. So how is the law enforced? This is the particularly appalling part of this law. SB 8 allows anyone to sue another person for assisting someone who has had an abortion after 6 weeks of pregnancy. And it rewards them $10,000 and attorney's fees if they succeed in the suit. It's in essence creating a bounty hunting scheme that encourages the general public to bring costly and harassing lawsuits against anyone who they believe has violated the ban. The pregnant person, by the way, is exempt from being sued. So it's just the people that help the pregnant person. The law allows anyone to file a lawsuit, including a parent, an abusive partner, or even a stranger, without any sort of showing or harm or relationship to the person who is pregnant. The law authorizes lawsuits against health center staff, abortion funds, providing financial assistance, anyone who drives a friend to obtain an abortion or otherwise provides help, and even a member of the clergy who counsels an abortion patient. Before the law even went into effect, anti-abortion groups in Texas set up an online form enlisting people to sue and encouraging anyone to submit anonymous tips on doctors, clinics, or others who violate the law, such as anti-abortion group Texas Right to Life's website. Pro-life, it was called Pro-Life Whistleblower. The site was quickly flooded with fake reports and is now shut down, last I've heard. So advocates fear that the law will subject abortion providers, clinic staff, and abortion funds to ceaseless lawsuits that eat up time and resources, ultimately shutting them down. So what did the courts do? The Center for Reproductive Rights filed a lawsuit against all the judges in Texas, challenging the law as a violation of Roe versus Wade and Casey versus Planned Parenthood, cases which for over 50 years have established the constitutional right to abortion. And the case requested a preliminary injunction to block the law from taking effect. And again, they sued the judges because they couldn't sue the state because the state wasn't responsible for enforcing it. It was random strangers. The lawsuit actually also enjoined a particular anti-abortion protester who was threatening to bring lawsuits. The lower court scheduled a hearing for Monday before the law was supposed to take effect, which was September 1st. In the meantime, the Fifth Circuit intervened and canceled the hearing the weekend before it was supposed to take effect. The Center for Reproductive Rights filed an emergency petition to SCOTUS, and the law went into effect on September 1st before SCOTUS had a chance to rule, or before they did rule. A day later, SCOTUS denied the petition, ruling on procedural grounds, while explicitly denying their decision was based on any conclusion about the constitutionality of the Texas law, but they did allow it to go into effect. So the law stayed in effect. As a result of SB 8, reproductive health care providers in Texas have ceased offering abortion services after 6 weeks of pregnancy. On September 3rd, a Travis County judge entered an order barring Texas' right to life from filing a lawsuit against Planned Parenthood clinics and staff, and some other plaintiffs have won similar orders. So what has been the impact? The law has stopped most abortions in the state of Texas. The Guttmacher Institute estimates that the law increases the average distance people have to travel to obtain abortion care 20 times, from 12 miles to 248 miles. They argue that the law is particularly harmful to women of color in Texas, where 19% of Black women and 20% of Latinas live in poverty. In addition to traveling out of state, people are likely ordering abortion pills online and using them at home. And I'll talk more about that in a second if I have time. So how is the law being challenged? In addition to the Center for Reproductive Rights lawsuit, which is ongoing, last Thursday, the Department of Justice filed a lawsuit arguing that SB 8 clearly violates Roe v. Wade and Casey versus Planned Parenthood. And also they argue that it violates Article 6 of the Constitution, the Supremacy Clause, which establishes that the US Constitution and federal laws take precedent over state laws and constitutions that are contrary to them. The Justice Department argues that the Texas law conflicts with federal law by purporting to prohibit federal employees and non-governmental partners from carrying out their responsibilities under federal law related to abortion services, such as Medicare coverage of abortion in cases of rape and incest, and subjects these federal employees to civil liability and penalties. I'm going to pop an article I wrote for Ms. in about the federal DOJ lawsuit, as well as an interview I did last Friday with Maura Healey, who is the Massachusetts Attorney General. Basically, and I'll talk more about that in a second. So Texas hopes that private enforcement of the law can be an end run around the 14th Amendment and Roe versus Wade, which only applies to state action, not private action. It's a devious and dangerous scheme that could allow the total abrogation of constitutional rights, not only to abortion, but other areas, including things like the Second Amendment, gun rights, which that gives me a hope that the Supreme Court ultimately won't uphold this strategy. So I interviewed Maura Healey, and Democratic state attorneys general are also considering filing a lawsuit because of the negative impact that SB 8 is having on neighboring states. Healey on Friday said that Texas women are now going to surrounding states, including Colorado, New Mexico, Nevada, California, and Oregon, and burdening those states. She said, and I quote, "Women from those states are going to be denied access to abortion because providers are booked up with Texas patients. It's going to delay access to abortion and infringe on the constitutional rights of people seeking abortion in other states." She says, what could have been a medication abortion might have to become a procedural abortion because of delays. And in certain states where the state pays for abortion, it could also cost a lot to the state that they're having to cover out-of-state people coming in from Texas. In addition to the DOJ suit and the CRR suit, as well as potential action by state attorneys general. And by the way, Maura Healey is the co-chair of the Democratic State Attorneys General Association. Okay, I'm wrapping up in just a second. The Congress has introduced the Women's Health Protection Act, which is federal legislation that would codify Roe v. Wade and would stop things like the Texas law. And in addition, there's currently a Supreme Court case involving abortion called Dobbs versus Jackson Women's Health Organization, which talks about pre-viability abortion bans. And so it's going to be critical. That case will be heard in October. It will be ruled on in June. It's another critical piece. And so just to wrap up briefly, I just want to say that there's a lot of underground resistance on the ground. Abortion pill advocacy groups are pushing folks to order abortion pills online. Aid Access is providing advanced provision of abortion pills for $105. It takes about 2 to 3 weeks, so they're encouraging people to order them right away. So if they do need them eventually, they can get them right away. There's also other online providers that people can order from and get them very quickly, like within a couple days. So that's another thing that people are trying to educate folks in Texas about. And we know that people are ordering abortion pills online as well as traveling out of state. And I just popped an article that I wrote about the campaign around getting people abortion pills. And again, Aid Access is physician supervised, but the physician is out of the country. So they're not subject to any sort of criminal penalty by Texas, which is trying to ban mailing abortion pills by doctors within the state. All right, sorry I went on so long, but I can answer more questions about any of that. I'm gonna pop one more piece I did about how talking about fetal heartbeat is misleading in the box.
Thank you so much, Professor Baker. So the audience knows we are trying to go around 10 minutes for the speakers, so there's plenty of time for Q&A. Along those lines, feel free to write a question in the chat. I will be monitoring the chat. You can write it to everyone. You can write it to me. And if you want me to call on you when we're done with the presentations in about a half an hour. So that was wonderful. I really appreciate laying the groundwork so we're all on the same page about what this law is and why for people who believe in choice, it's very dangerous. Now we're going to turn to Professor Krystale Littlejohn. She is an assistant professor of sociology at the University of Oregon. She studies race, gender, and reproduction, and she is the author of a new book, Just Get on the Pill, The Uneven Burden of Reproductive Politics, recently published by UC Press. We hope to host her for a book overview in the coming months. Her work has been published in Demography, Gender and Society, and the Journal of Health and Social Behavior, among other outlets. We're very honored that she decided to join us in her very busy schedule. So thank you so much, Professor Littlejohn. The floor is yours for 10 minutes.
Thank you so much, everybody. I'll keep my comments expansive but brief so we can hear from everybody. I'm really excited to be joining the panel today. In my comments, I want to focus on how we should be thinking about birth control in relation to the ban in Texas and abortion restrictions elsewhere. So just a brief overview, my work focuses on micro interactions around contraception and abortion. So I've focused on examining young women's experiences, young cis women's experiences, trying to prevent pregnancy with their partners, and really trying to get into the gendered, race, and class dynamics about how they face particular challenges doing so because of our social approach to birth control in this country. So I'll focus on one of my frustrations about the law because it's part of a phenomenon that we see playing out in our society, and it's simply being leveraged via the ban. And that's this idea that, as Dr. Baker was mentioning, we use private citizens to enforce unjust social practices. The idea with the law is that people can sue other folks who facilitate getting access to an abortion, and that's egregious, of course, but the use of private citizens to pressure and coerce relatives, friends, and partners into avoiding abortion is powerful because it's something that already happens. Texas just now gives people the option of using the law to violate other people's reproductive rights. In my own work, using interviews with young women in California, women told stories about having their freedom encroached upon after they experienced a pregnancy. And this is something that I dedicate a chapter to in the book because it came up as something that was really important. They talked about partners and family members trying to pressure them into giving birth when what they really wanted to do was have an abortion. And their partners and families might have even known about this before a pregnancy occurred, but they nonetheless tried to constrain their behavior when a pregnancy actually happened. For women, they might have acquiesced and gave birth, or they might have tried to stand their ground and had an abortion. The law in Texas, however, now arms people to not only use the power of social expectations and responsibility to constrain people's freedom, but to use the power of the courts to facilitate reproductive coercion. In fact, a Washington Post article from a couple of weeks ago discusses this very idea when they point out that an anti-abortion rights leader, quote, predicted that fathers and other relatives will report abortions obtained by female relatives unhappy that their daughters or sisters chose not to continue their pregnancies. It's egregious behavior, right? That's plain and simple. What I see as a researcher who has studied both contraception and abortion is also another threat to people's reproductive freedom in light of the abortion ban in Texas that we pay much less attention to. And that this is, in fact, a more or less predictable response at this point, even though we take it for granted as not being particularly problematic. And that's, in this case, is wherein as soon as there is a new particularly serious threat to abortion, there are these accompanying calls for people to find a reliable form of prescription birth control. And it's couched in terms of protecting people's reproductive freedom, but I see it as a violation of their right to reproductive autonomy. We shouldn't encourage people to use prescription birth control as a solution to abortion restrictions. We should fight abortion restrictions. So in the remaining time that I have available, I want to say a little bit about what role I think prescription birth control should play in conversations about abortion restrictions. And I also want to talk about the framework that I think should guide our thinking. So first, contraception and abortion, this will be no surprise to folks here, are both vital medical services required to help people live their best lives. My research has made that very clear to me. Lack of access has negative consequences for families, for schooling, and for all people worried about pregnancy. People shouldn't have to choose between contraception and abortion, and they should never have to worry about losing access to them. But that's exactly what's happening for people around the world. We know that over 400 million women of reproductive age use prescription birth control methods like the pill and the shot, and 1 in 4 pregnancies end in abortion. Whether in the United States or beyond, people clearly need and deserve access to a full range of reproductive health tools. We have to make this a priority, and we have to fight restrictions on abortion. Calling on people to use prescription birth control as a solution to having their reproductive rights violated is itself a violation. In light of bans, we have to find ways to ensure that people continue to have access to all of the methods that they need to meet their reproductive goals. And this requires that we shift our framework from simply thinking about preventing pregnancy and birth to thinking about people's reproductive rights and reproductive justice. Reproductive justice doesn't just champion the right not to have children, but also the right to have children and the right to parent children in safe and healthy environments. And the key tenet in reproductive justice is that we have to eradicate reproductive oppression and uphold reproductive freedom. In light of increasing restrictions and bans on abortion and growing pressure to regulate contraception, advancing reproductive justice requires a multi-pronged strategy. Key to that strategy is agitating for change on the ground, as countless reproductive justice organizations do. But I think that fighting the law in this case also means that we have to continue to interrupt messages that suggest that anybody's desires, aside from pregnant people's desires, matter. Surveilling and regulating their bodies is just part of a long-standing assault on their rights in this country. The power with this particular strategy, as I mentioned, is using everyday people to violate the rights of neighbors, friends, and family members, right? While it may be that anti-abortion activists are going to most aggressively try and enforce this law, I have no doubt, based on my research, that it's also going to be everyday people who also play a role, and the behaviors of those people also matter and have to be addressed. To address them, I think that we have to not only focus on the ban itself, but also its mechanism of operation. We as individual people can't control what the Supreme Court has done, but we do have much more power to challenge the messages that are so pervasive in our culture and that operate to constrain people's reproductive autonomy. To the extent that other states move to enact similar restrictions and are successful in doing so, it'll be even more important for us to try and shape how our fellow citizens in this country deploy their social power. Obviously, as a sociologist, I want to be very clear. I'm not advocating just for individual solutions for a systemic issue, right? We have to fight back via as many different mechanisms as we possibly can, and that should be our central goal. My goal here is just to draw our attention to overlooked ways that social messaging that is so pervasive in our culture ends up encroaching on people's right to make decisions about how they manage their pregnancies. And it's being leveraged in this case to support reproductive violations. So with that said, I will go ahead and stop there. I'm very much looking forward to hearing from the other panelists and to discussing things further in the Q&A. Thank you, everybody.
Thank you so much, Professor Littlejohn. great segue between the law's origins and legal effects to the everyday personal effects. We're moving next to Professor Josh Wilson. He is joining us from the University of Denver, where he is professor and chair of political science. Professor Wilson's research and publication concern the varying abilities of conservative political and social movements to use law broadly defined in the pursuit of political ends. His most recent book is Separate but Faithful, The Christian Right's Radical Struggle to Transform Law and Legal Culture, co-authored with Professor Amanda Hollis-Brusky at Pomona College. His earlier books are The New States of Abortion Politics from Stanford University Press in 2016, and his first book was The Street Politics of Abortion, Speech, Violence, and America's Culture Wars, also with Stanford University Press in 2013. It's obvious he has quite a bit of expertise to share with us on the origins of this law. Thank you, Professor Wilson, for joining us.
No, thank you for having me. I'm going to set a little timer for myself here because I wrote a range of notes, not knowing what other people would talk about, so I wanted to make sure that I would have something to fall back on. But the main thing that I want to do is try to put SB 8 in different larger political contexts, historic and also kind of present, to think about where this law came from and what it stands to do to abortion politics as we move forward. So the first thing I want to talk about here is the enforcement mechanism. Right, Carrie brought this up in the beginning. It's kind of the most kind of compelling, or one of the most compelling things about this law, and it's both unique and familiar. So it's unique in its kind of substantive focus in targeting abortion. It's unique also in conservatives embracing private enforcement mechanisms in the law here. And it's particularly unique in how it really opens up the scope of who can litigate. It makes it very much a free-for-all of who can invoke kind of the power of the court as a coercive mechanism here. But it's also familiar in this kind of reliance on private enforcement mechanisms for getting around what the state otherwise cannot do, right? And private enforcement, in this instance of what they're getting around that they otherwise could not do, is Texas, through Casey and other abortion case law, is barred from banning abortion before viability. So roughly, let's say 24 weeks. What this law does, right, is roll it back by 18 weeks before then to make the cutoff at 6 weeks, right? So what Texas is doing is circumventing precedent that creates a bar on what they can do directly, right? And so what they've done is they've deputized everybody else who's not part of the Texas state government to enforce this law, right? And this is familiar to something that we've seen in terms of, well, private enforcement is familiar to something that we've seen with progressives in the past. It has kind of a history that a lot of political scientists will link to the civil rights movement, but we see really expand out from there. And the connection here, like I said, the substantive difference is significant. So what I'm talking about here is the mechanism that the state is relying on, right? And what we see here with the civil rights movement is there's this desire, as we are creating civil rights laws, to have the state enforce these laws. But conservatives in both parties blocked that. They opposed it on the grounds of kind of creating a larger federal government, but also on the grounds of trying to blunt the effects of civil rights laws. And everybody basically expected that if you relied on private enforcement, it would mean that there would be very little enforcement, because people who stood to benefit from civil rights laws wouldn't have access to courts, so thus they couldn't bring cases, thus civil rights would kind of exist on paper, but not in reality, right? To everybody's surprise, really, after this, is that private enforcement proved to be a robust mechanism. And it became robust largely for political scientists out of University of Kansas. Chuck Epp talks about what are called support structures. And so that is, what are the existing surrounding institutions that could enable people to use the courts? And so he basically argues that, you know, resources and lawyers were made available, and thus private enforcement became a significant means of enforcing law, right? And as progressives learn from this, they spread it to a range of other areas where they ran into the lack of capacity of the state and thus relied on private enforcement mechanisms. Now, conservatives, once they recognized that this could be a robust means of enforcement, fought against it. They started to dismantle access to the courts, to create barriers to litigation, and to demonize private enforcement, right? That became part of what we see with conservative rhetoric over the last 50 plus years, is this demonization of the sue-happy US public, right? So there's a bit of an irony here in that conservatives have embraced this mechanism in SB 8, right? Embraced the idea of private litigation, and beyond that, have untethered it from standing, which is, that you have to be affected in civil rights law and other things. You have to be directly harmed in order to bring a case. With SB 8, you don't have to be harmed, which is why I said this untethers it from the limitations that we see on other private enforcement mechanisms and opens it up to a massive amount of litigation. And then on top of that, Texas has created incentive systems to bring litigation and to reduce the risk of bringing litigation under SB 8. So what I mean by this, right, is we have the people commonly point at the $10,000 marker of what you can stand to gain. That, by the way, is a floor. That's the minimum of what you stand to gain if you sue under SB 8. So you can get more than $10,000. But on top of that, if you bring suit and you lose, the person that you sued cannot then recoup their legal costs from you. But if you sue and you win, you can recoup your legal costs from the party that you sued. So Texas has created this really significant incentive system to bring litigation and to protect those litigants from any costs if they lose, or the full effects of costs if they lose in bringing litigation. So what that also does is it creates the incentive to bring cases even if you lose, because you're still costing time and resources and emotional energy from those that you sue, right? And this, again, is kind of ironic, right? Because conservatives have long demonized runaway litigation. And essentially what they're incentivizing here is runaway litigation, right? So why did they do this? Well, this also reflects something about abortion politics as a whole, which is abortion politics is really marked by experimentation and recycling and responding to shifting political opportunities, right? And of course, there's what I brought up earlier too, right? The biggest thing here is they recognize the viability problem, right? That they can't ban abortion for 24 weeks. So you innovate and you experiment and you find a way around it. That's what we see with SB 8, right? And then we need to talk about shifting political opportunities here, right? One, there was a major change in anti-abortion strategies during the Trump years. Basically, anti-abortion activists saw Trump's victory and saw Trump's subsequent restructuring of the US Supreme Court as massively changing the political opportunities. They were now going to have a friendly US Supreme Court. And so they shifted from having an incrementalist chip away at Roe strategy to many states and kind of upstart anti-abortion organizations going for much more aggressive kind of moonshot chances to try to directly challenge Roe or significantly move beyond what the court has been comfortable with before. Another change that allows SB 8 to function is that over the past few decades, conservatives have developed robust litigation resources. So they now have the support structures that allow them to bring a high volume of cases, that we can see coordination happening easily between anti-abortion activists and the conservative Christian legal movement that enables SB 8 to stand as a real potential kind of threat here to bring litigation. Now, I have a whole bunch, many other points, but I have 1 minute and 44 seconds left. So I want to pivot then to one other kind of directly related thing here, is the US Supreme Court ruling about this, so Holman's Health versus Jackson, does an interesting thing to the politics here and to the mechanism of SB 8. So one of the ways that the court essentially upheld SB 8 to allow SB 8 to go into effect was to say nobody's using it. And the one person in this case that we're reviewing said he's not going to use it right now. So nobody's using the law, so there's no reason for us to review its constitutionality right now. That creates a weird dynamic, is that allows the law to go in effect. It creates a threat to clinics and providers, and thus you see clinics and providers stopping to provide abortion after 6 weeks, right? But it also creates a disincentive for anti-abortion activists to use this law, because the second they litigate, they've used the mechanism which allows it to be reviewed by the court, which could then enable the court to shoot it down as an unconstitutional violation. So we have a weird standoff here, where conservatives who really want to use this law know that if they do, they might end it. So they're in a position where they can say, well, we want to use it, but if we don't, it still has a massive chilling effect that's cutting off abortion access. If we do use it, we put that chilling effect at risk. And then on the other side, clinics, the longer the standoff goes on, recognize, well, if it's not going to be used, maybe we can violate the law. That could then do two things. It would trigger a court case, which could then trigger review, and they'd see what happens. But it also exposes that clinic to massive risk, right? Because they're now exposed to litigation risk. And so there's this interesting standoff, and I'm very curious to see kind of what happens here. As you probably heard, that was my timer. Other things that I can talk about in Q&A if you want to are kind of the health outcomes that stand to come from this, the politics of that, and then what that does to democratic political opportunities, and then also what this tells us about intra-court conflict within the US Supreme Court. But I'll abide by my own timer and stop there. Thanks.
I appreciate that. So much more to say, and it looks like we're going to have plenty of time for Q&A, so that's exciting. Our next speaker, we're moving beyond the United States because reproductive justice is obviously not just a domestic issue. We've just had a recent amazing change south of the border that's creating this irony that people are saying that women might cross the border to Mexico to be able to access abortion. But our next speaker is Professor Cora Fernandez Anderson, who is Assistant Professor of Comparative Politics at Mount Holyoke College and the co-chair of one of this event's sponsors, the 5-College Certificate on Reproductive Health, Rights, and Justice. Her research focuses on reproductive rights in Latin America. Her book, Fighting for Abortion Rights in Latin America, Social Movements, State Allies, and Institutions, was published by Routledge in 2020, and it explores abortion reform in Argentina, Chile, and Uruguay. It's a pleasure to meet you virtually. I can't wait to meet you in person, and I look forward to hearing what your thoughts are on this topic. Thank you, Professor Anderson.
Well, thank you for having me today. So as it was said in my introduction, I work on reproductive rights in Latin America, and my last project was studying abortion reform in the southern cone of this region. So I really want to reflect on Latin Americans' lessons for the US today. So just to give some context, Latin America has historically had restrictive legislation on abortion. Until recently, there was legal abortion on request only in Cuba. And there's still today 4 countries that ban abortion under all circumstances, even when the life of the pregnant person is at risk. Having said that, Latin America is also going through an explosion of feminist mobilization as we speak. A cultural change that has surprised many, but that really seems unstoppable at this time. In the last 10 years, Uruguay, Argentina, and Mexico, just last week, have legalized abortion on request in much more generous terms also than the US, since abortion in all the Latin American countries that have it legal is free in public hospitals. Other countries like Colombia and Chile have moved away from a total ban to a system of exceptions, legalizing abortion under certain circumstances. So change is really coming in this region. I have been teaching a class called The Politics of Abortion in the Americas for 10 years now. And we usually study the US and some cases from Latin America, compare across, trying to understand why the restrictions in some places, why the legalization in others. And in the past, we used to bring lessons from the US experience to Latin America. But more and more, I realized that Latin American successful struggles to legalize abortion also have lessons from those fighting for all the lack of access to abortion in the US. So here is a little bit of the analysis that I bring, from the south to what is happening now in the US. So the first big lesson is that mobilization works. If you have checked what is going on with feminist mobilization in Latin America, you will see that has been at the core of many of these successful, policy reforms. So to think about what these movements are doing, I will be talking about 3 different strategies that they have put in place and have led to, in some cases, legalization, and in some cases, no legal reform, but increased access, which I think also it's very interesting how they were able to find alternative strategies when legal reform was not available. So the first strategy is a traditional strategy of pushing, legalization through Congress or the courts. In cases, for example, such as that of Argentina, which legalized abortion recently in December of 2020, the bill that was introduced in Congress was drafted by the movement. So there was like different organizations that come together through different panels at all the different provincial levels, and then at the national level that get together, receive a lot of input from activists, and drafted the bill that then was introduced in Congress by supportive legislators. So the movement had really direct input in the terms in which legalization should happen. So I think that was really interesting. And when we think about the strategy of advancing legalization in Congress, I think it's interesting also to look at the different frames that have been used. While I know that frames are very context specific and maybe what resonates in one society might not, resonate in others, I still think it's relevant to analyze the frames that have been used in Latin America to see if there's also an option to expand the way that we are fighting for abortion here in the US. So abortion in Latin America has been framed as a public health crisis, as an issue of social justice, given that those affected by the consequences of illegal abortion are always from vulnerable populations. They have also more recently framed the criminalization of abortion as a case of violence against women. So really embed this fight for abortion rights also within this larger framework of fighting against violence against women. Very clearly, the movements say that without legal abortion, there cannot be a world free of violence for women, and that the state is directly responsible for the deaths by unsafe abortions, which they actually call these deaths cases of femicide. Finally, activists have also said that legal abortion is a debt of democracy, that without legal abortion, women are just second-class citizens. So also bringing in, some different frames that have been resonant because of how Latin American societies have struggled to consolidate their democracies. So this is a little bit of the traditional strategy, but 2 other strategies that are more non-traditional or not going through more institutional channels have been developed as well. And they have looked for alternative ways to increase access to abortion when legal reform was not happening. So in a context in which many politicians, political parties were really ignoring the need for abortion reform, and bills many times sat in Congress without being discussed at all and without being placed in the agenda for decades sometimes, activists felt they needed to do something now to help those in need of an abortion. So they developed 2 strategies. The first one that I called usually the use of the health exception. So many of these countries with restrictive legislations have health exceptions, health clauses, meaning that they ban abortion in general, but they allow abortions if the health of the pregnant person is at risk. However, these laws are usually quite vague and very rarely regulated. So what do we mean by health? Does this refer to life-threatening conditions or any health condition? Who decide? Is it the doctor or the patients actually, if they're willing to take the risk, of a health problem, continuing the pregnancy or not? So this has been mostly vague and left, undecided, maybe until some of these cases are submitted to a judge and the judge rules implementing and enforcing the law. So in line with these vague recommendations, some health professionals that call themselves, for the right to choose and supportive of the right to have an abortion decided to reinterpret the letter of the law in a favorable way with the goal of increasing access to abortion. So they took the World Health Organization definition of health, and I quote, the state of complete physical, mental, and social well-being, and not merely the absence of disease, and began providing abortions in any case of an unwanted pregnancy, given that they could attest that all patients who did not want to carry the pregnancy to term were going through intense stress and anguish that affected their health. So this was very empowering for those patients because they were going to have an abortion in a country which actually criminalized the practice, but at the time of meeting with these particular health professionals, they were told, well, this is actually legal, because if you take health in these comprehensive ways, what you're doing is actually allowed by the laws of your country. So this strategy was also helped by feminist bureaucrats who usually working within health ministries that released at the same time health protocols to all public hospitals that embrace this interpretation of the law. And they explicitly stated what health meant with this comprehensive definition, so that they, if these doctors will get into future travel legally, they had like some government documents to really back down their reinterpretation. So this is, one of the things that has been happening in many Latin American countries to work through increases access, even when there's no like legal change happening, because legal change has been taking longer in many of these cases. The final strategy that feminist activists put in place, usually we describe it as direct action, and they, again, impatient because Congress or the courts were not doing enough, they started doing two things. The first one is setting up hotlines, providing information on how to safely have a self-administered abortion with misoprostol, which is available in the region, even though abortion is still illegal in most cases because misoprostol is used for other medical conditions. So it is possible to get it in these countries. So people will call to this hotline and get clear information on how to have an abortion at home. They have been, they were protected, these activists, by the right to information, but for this, they really had to follow very strict scripts. So they were not able to, on the phone, advise people on what to do in particular situations, but they had to limit themselves to repeat, according to the World Health Organization, the instructions for a safe abortion is to take the pill every 2 hours under the tongue and then wait, and every single step as how to safely have an abortion at home. So that was one thing that flourished and is still flourishing in many Latin American countries, that abortion is illegal. The other step that some activists, took, even going further, aside from hotlines, some feminist collectives set up service of abortion doulas. So they will actually meet in person with the person that had that wanted to interrupt a pregnancy, explain face-to-face how the misoprostol worked, how to have an abortion at home on your own and safely, and even sometimes be with them, when they were having the abortion. And the interesting thing that this particular activist did was really reframed the notion of abortion. If in the region it had been, attached to something that brings shame and taboo, and it's taboo and it's a sin, they really started talking about that they were providing feminist abortions, abortions that are empowering, that are the beginning of something in your life, because you're taking charge, making a decision that is important for you, and that from then onwards you can continue, with the plans that you had. Some years ago, I believe it was 2015, we invited one of these activists, that is the group in Argentina is called Socorristas. Ruth Surbrigen was here for us in one of the CLIP conferences for reproductive justice. And she actually was telling, how initially they received inspiration from the feminists that in Italy have, taken, abortion on their own hands, and also by the Jane experience in Chicago in the US, which really made me think, about the power of transnational feminism and how it's really coming full circle, because Jane, inspired this feminist in Argentina, and now these feminists are also, bringing inspiration back to us here in the US on how to deal with these struggles. So I'm gonna stop there for the purpose of time, and then looking forward to our conversation. Thank you.
Thank you all so much. That was a rich conversation. We have some questions in the chat. There's many ways in which to start engaging in the conversation. We have 40 minutes, and so I'm really open and excited to hear what our audience members think. The first question that I want to go for, I'm going to go from the bottom up in our panel and in our chat box, is from Lorena Vodnica. If you want to speak yourself, feel free to unmute and turn on your camera and speak. Otherwise, I'll repeat your question. it's asking you, Professor Anderson, to expand a little bit about if there is a Latin American perspective on women as second-class citizens and how you might elaborate on that perspective.
Yes, thank you. Yeah, this was one of the frames that have been used quite successfully in Latin America because of how the kind of frame of democracy, because of how much, it took these countries to really establish and consolidate that democracy, which, the last wave of democratization happened in the 1980s and 1990s. And most of the countries have actually, until this point, there have been some exceptions, have democratic stability ever since, with, with lots of problems by the side. So it was something that people could relate to, like something that they have fought for democracy for so long. And the idea that not, continue to criminalize abortion was really not making that democracy available to all of us. Actually, half of the population of those that actually can get pregnant really started resonating. So movements started using it as was one of their ways of trying to raise awareness that this was a particular policy, that reproductive rights have not been attended or addressed, by these democratic governments. So we got political rights back, we got, lots of human rights, in place to prevent, dictatorships from happening again and human rights abuses from happening again. But reproductive rights were always left on the side without being addressed. So they really want to link, that idea of the need to legalize abortion to the rest of other human rights that have been addressed until that time, and other, political rights and democratic rights, and how this was, preventing women and those that can get pregnant from really having complete autonomy as citizens.
Thank you so much. There's a couple more questions coming in the chat. I'm going to direct your attention to the chat. There's a question about how everyday people can engage in advocacy. And Professor Baker is sharing many links with resources for people who are interested. There are funds to support financially people seeking abortion, and there are planned actions. One is here in the Pioneer Valley on October 2nd. Please, in the chat, feel free to share additional insights for people who are feeling like they want to really do something. And if the panelists have other thoughts on what people can do, feel free to share those either verbally or again in the chat. Professor Wilson asked if he can comment on Professor Anderson, and I want to open it up to our panelists if there's something that sort of caught your eye or ear in what the other panelists said that you want to respond to, and then we'll go back to the growing question list. That's excellent. Thank you.
Okay, thanks. So one thing I just wanted to comment on really quickly, in relation to kind of thinking about US political history around abortion politics, and then thinking about other countries and Latin American experience and so forth. So one of the things you brought up was kind of mobilization and mobilizing harm that was being caused to women, and the need to step in to help protect women. And this relates to two things that I've been thinking about with possible or likely health outcomes related to SB 8 is, one, if we think about the trajectory of US abortion politics, and we go back to the pushes to liberalize abortion laws in the US, right? That was the rhetoric used in the US as well, as talking about the harms that were happening to women and the need to protect women, right? And then of course, one of the symbols of the abortion rights movement becomes like the coat hanger, right? You ask a lot of people today, I feel like if I went into one of my classes and I asked them what the coat hanger was, I wouldn't expect a huge response, right? Because the rhetoric and the language and the symbols used have changed over time. And so in thinking about SB 8 and the real risk of adverse health outcomes for women, it stands to essentially return us to an earlier stage of US abortion politics, where health outcomes are can be mobilized by abortion rights activists. And then the other thing is that this problematizes the where the mainstream of anti-abortion activism has gone. They've migrated away from the pro-life language, and in more recent years have really moved towards defending their legislative actions as pro-women, that we need to regulate clinics in order to protect women from those clinics. What the Trump era did, and the abrupt, like basically the disruption to abortion politics and the anti-abortion movement, was that it opened up more opportunities, like I said, for much more aggressive campaigns that actually fly in the face of this protecting women line that the anti-abortion movement has adopted. And SB 8, of course, really runs counter to that as well. So it's, you can kind of see SB 8 and the last 4 years as this really disruptive period that has destabilized not just American politics in general, but abortion politics, and stands, like I said, to return us and recycle kind of older forms of rhetoric that we see in the movement that have kind of moved back a bit.
Thank you, Professor Wilson. I want to ask a question of Professor Littlejohn that's in the chat about how you feel the role of contraception falling generally on cis women alone. Do you think it would help to show how restricted access affects cis men to improve access for women, cis women in this case?
Yeah, I really appreciate this question. I think one of the biggest things that I found in my research is just how challenging many people who take prescription birth control find using birth control consistently. And we don't pay nearly enough attention to this in whether it's the broader discourse on pregnancy prevention and responsibility, or even a feminist discourse on birth control use. But in the reality is that many people struggle with it. They may dislike it. They keep trying to use it, right? But trying to prevent pregnancy for approximately 30 years is hard. It's something that's really hard for people to do. And so I actually was just working on an op-ed about this. The reality is that people need contraception and abortion. They need these multiple tools to help them manage their fertility and to have their families look like what they want their families to look like. And as much as people emphasize how effective some of these prescription birth control methods are, that's kind of one of the main pushes to use prescription birth control, is that the methods are so effective. The reality is that they're only as effective as they are because people can commit to using them. And if we change our language around condom use, condoms can become more effective in practice as well. And so for me, I think the biggest thing to keep in mind is just that it's important to try and avoid thinking of birth control, of prescription birth control and abortion as being kind of on one side or the other, and instead just to think about them as being tools that help people manage their experiences. And as the questioner was mentioning, it's not only beneficial for the pregnant person, but it actually ends up being really important for helping their partners prevent pregnancy and births as well. So I appreciate this question for sure.
Thank you so much. That resonates quite a lot. I'm going to take two questions together a bit, geared more towards Professor Baker. So the question about the legal landscape for self-managed abortion and what types of legal resources are now available for self-managed abortion. And along those lines, can advocates use Texas media to promote choice? And that's, thinking about teaching women how to use self-managed abortions. Will they be subject to legal prosecution, or if they're providing general information, or do we think this is really about only specific women having gotten an abortion?
So self-managed abortion is spreading like wildfire, both in the United States and around the world, but particularly here in the States, where there have been all these restrictions that have closed down clinics, required that people travel hundreds of miles to get care. And the coronavirus has sort of accelerated access to abortion pills via mail, because the FDA restrictions on the abortion pill mifepristone were temporarily lifted during the pandemic, are still lifted. And you have this burgeoning of these online abortion clinics where either asynchronously through video conferencing or by texting or filling out forms on encrypted platforms, people can get doctor supervised abortion remotely. Abortion pills. Now, this only works in the first 10 weeks, although you can actually use it longer, but it's only FDA approved for the first 10 weeks. They're extremely safe, and the telemedicine provision of abortion pills have been shown to be extremely safe. The UK went entirely online, and there was a study based on 11,000 pills, or 11,000 telemedicine abortions done in the UK, and the effective rate was extremely high, like 95%, and the safety, it was extremely safe. And I've written articles on all of these studies and this research, so if you want more information, I can share that with you. I'm popping in the box an article about the growth of both telemedicine abortion and self-managed abortion. Self-managed means that you just buy the pills online and use them yourself, looking on websites about how to do it. It's safer than ibuprofen, or it's safer than Tylenol. It's 6 times safer than Viagra, which is handed out like candy, right? You can order that online very easily. So it's really, really super safe. But the anti-abortion movement has worked to try to stigmatize it and make abortion sound dangerous. They call it chemical abortion. It basically just blocks the hormones that maintain a pregnancy. The first pill, mifepristone, and then the second pill, misoprostol, just causes contractions that expel the contents of the uterus. So it's really, it induces a miscarriage, basically. And it's very safe, very easy to get. Like I say, Aid Access sells these medications for $105. Others charge more, but get it to you quicker. Aid Access is now providing advanced provision, so you could just have it in your medicine cabinet. So if just in case you miss a period, you don't even need to take a pregnancy test, just take the pill. Some doctors are now providing it as missed period pills, where they're not even finding out if people are pregnant. Just if you've missed a period and you want your period to come, you take the pills. And for some people, they don't want to know whether they're pregnant and whether they've had an abortion. They just want their period to come back. The legal status, you know, very few people, especially in early pregnancy, have ever had any legal problems because nobody knows they're doing it. And there's no way to test for having taken the pills. The only way is if you have a problem, go to hospital and tell somebody that you took the pills. But they can't test your blood and find it. I mean, it's just, there's no way to tell. That said, especially if you use them later in pregnancy, you can use them through the entire pregnancy to induce abortion, like 20 weeks you can use it. But the problem is later in pregnancy, you have a fetus. And a lot of people that have been criminally prosecuted, it's because either like illegal disposal of a fetus, or they've been, you know, there've been sort of aggressive prosecutors. Very few states have laws against self-managed abortion, but aggressive prosecutors can find ways to go after women. And of course, the women that are disproportionately targeted are low-income women and women of color. If When How has created a Repro legal helpline for people who have legal problems connected to self-managed abortion, and I can pop their link into the box. I've already popped the link of Plan C abortion pill guide. They give a state-by-state guide about how you can access abortion pills, both doctor supervised, but also if you just want to order them on your own, and other information about how to use them. The question about could you go after somebody sharing information? So people still have First Amendment free speech rights to talk about the fact that abortion pills exist and to talk about using them. You have to be very careful though, not to like actually advise somebody to use it. So speaking generally about it as it exists, here's how one might use it, use third person language, you still have your First Amendment rights. Now that, you know, it may, a aggressive prosecutor might decide to go after you and cause you a lot of trouble. But, you know, as long as you're not like acting as a physician and giving medical advice, as long as you're just talking about the fact that abortion pills exist, you should be fine. But, you know, I don't think it's been, we don't know what this new bill will be used. And aggressive Texas prosecutors could go after anybody for anything because it's very vague. That's one of the grounds that it's being challenged on. The law is extremely vague. It just says aiding and abetting. And so we don't know how it could be used. Oh, thanks. Somebody put the Rebro Legal Helpline. Jennifer, thank you for putting that.
Thank you. I'm gonna turn to some of the questions around the law and the courts. We had an earlier question that was trying to situate this vigilante approach to enforcing civil rights back with the post-Plessy era of Jim Crow and really the suppression of civil rights. This comment by Mikhail Brangen says, I hope I'm pronouncing their name correctly. But should we focus a lot on fascism, they say, when we talk about backsliding, but in the US context, we should be alert to right-wing efforts to return to a pre-civil rights, states' rights, second Lochner era. Can any of you speak to what that particular provision for how to enforce this law says about where we're going in terms of our legal culture and the enforcement of rights, particularly for vulnerable minorities?
Sure, I can jump in there. So one of the, if we think about SB 8's enforcement mechanism in a broader, extending beyond this, right? Like I said, private enforcement has typically been used to circumvent barriers that people have found with kind of limited state capacity, right? But it's been restrained in the past through all sorts of mechanisms, right? About who can sue and so forth. And as I was saying, one of the things that this case or this law does is it untethers the enforcement mechanism from harm. And so it really opens up who can litigate. And if we think about this in kind of a broader theoretical context, this is a problem for what we've typically understood the state's role to be, is that, so I like going back to, in my classes, I talk about Max Weber a lot. So bear with me for a moment. Don't worry, we're going to go on a big theory dive here. But one of the things that we talk about with Max Weber is that the primary role of the state is to monopolize the legitimate use of violence. And so what that means is to take coercion out of the hands of the public, put it in the state, and then control it, right? So that there are legitimate uses of violence and coercion, and we essentially are ending vigilantism, right? And what we're seeing in SB 8 is the state ceding that power, ceding that role, and giving it up, and basically saying, I'm going to let members of the public use some of the massive coercive force of the state at their own discretion, right? And so we could see that as the state kind of surrendering this central role of monopolizing and controlling and civilizing kind of violence or coercion, right? And so then the fear becomes that if this mechanism is allowed to stand, then it spreads, right? One way that we can talk about spreading, of course, is that other anti-abortion states will adopt this, but then there's talk of like, all right, as was brought up earlier, California, go after Second Amendment rights through a similar mechanism, right? And so then people can kind of extrapolate out kind of an arms race of circumventing existing legal barriers through this mechanism. And what that does is it unravels the control of violence, the control of coercion, and starts opening it up to the public to use. Which, of course, by the way, leads to kind of like, if we keep going that out, is a pretty dystopian future.
So along these lines, people are concerned and questioning where we go with Supreme Court precedent and legal rights to abortion that have been relied upon for the past decades. So even though, meanwhile, we have this going on in Texas, we have a Mississippi case coming up in the Supreme Court. So what do our scholars have to say about that, our actual constitutional rights on abortion?
I think it's likely that the Supreme Court will either completely overturn Roe or significantly cut it back. It's clear there's a 6-3 majority that's hostile to abortion. The 3 Trump appointments were selected because of their hostility to Roe. So I'm very concerned that we're not going to have a constitutional right. And, you know, that's why I think the Women's Health Protection Act is so important, that we codify Roe. The problem is the Senate filibuster. It would pass the House. It would get a majority of the Senate, but it won't get the 60 vote filibuster threshold. And, you know, I'm really concerned that the court is going to do that. Overturn Roe.
To add to this too, right, is that what was most remarkable to me about the court's ruling or opinion with SB 8 so far is the division between Roberts and the rest of the conservatives. That Roberts recently signaled in June Medical Services that he was opposed. So to give a little background, right? Whole Women's Health versus Hellerstedt, 2016, appeared to be a very kind of robust understanding of abortion rights in a way that we have not seen the Supreme Court take. Then, of course, right after that, Donald Trump wins the presidency, the composition of the court significantly changes, right? And then we get another case out of Louisiana that looks very much like Whole Women's Health versus Hellerstedt. But the Chief Justice sides with the liberal justices on the court, but in writing, basically says, I'm bound by the recent court case, but he then lays out a way of incrementally moving away from Whole Women's Health versus Hellerstedt, essentially adopting an incrementalist chipping away strategy at Roe, right? And that for me looked like, okay, he's sending out a signal to anti-abortion activists and to legislative bodies. This is how you should proceed if you want to continue to aggressively regulate and erode abortion rights. What was remarkable about the ruling that just came out, or the opinion that just came out about SB 8 was, well, one, you need to notice that Chief Justice Roberts continued to side with the liberal justices in this. He broke with the rest of the conservative majority. So what we need to look at is that 5-justice conservative majority. What they signaled is they're not on board with Roberts's incrementalist approach. Rather, they are open to much more aggressive moves to quickly and aggressively go after Roe, to go after abortion rights. And so this is a big signal, right? And this is why the rest of the justices on the court were essentially screaming about the legitimacy of what the court majority had done and trying to gain leverage over those conservatives to essentially say, rein it in, right? And so this signals now to anti-abortion activists and to legislative bodies that they can continue to move aggressively because they have a 5-justice majority on the court that is open to those aggressive moves. So we really need to pay attention to what's going to happen with Dobbs versus Jackson Women's Health Organization, which is going to be talking about a 15-week ban, right? So again, getting rid of the existing viability line and moving things back earlier.
Can I move? I want to ask a question, use my prerogative as moderator for a second and get even bigger about what this means for our legal culture and the way we think about courts and the legitimacy of the legislative process and then courts. How do you all see this? And and that's for all the panelists, not just those who specialize specifically in law, but on how we think about, you know, what our rights are to control our reproductive options.
I think that progressive movements, civil rights movement, women's rights movement, gay rights movement have for decades thought of the courts as an avenue towards social justice and expanding human rights and increasing rights for people that are discriminated against. I think after Trump appointed 200 federal court judges and a third of the US Supreme Court, I think it's very clear we can no longer think of the courts as an avenue to social justice, which is not to say there won't be good decisions like district court decisions or some circuit court decisions, but and you know, there's surprises like Gorsuch in Bostock siding with the idea that sex discrimination includes gender identity discrimination. So I don't think it's totally hopeless, but I think that you know, we've got to work more legislatively to try to aggressively expand our rights in the Constitution. I mean, for instance, the Equal Rights Amendment, but also statutorily. We need to get rid of the filibuster. I'm a big supporter of expanding the number of justices on the Supreme Court. I think that's the only way to address the malicious and the activity of Mitch McConnell in hijacking the Merrick Garland seat, which is what's given them this hyper majority. And so I just think we need to not rely on the courts. I think they're not going to be what we need to get where we need to go. And I'm also a big supporter of just, getting medication and abortion.
I think for me, I tend to think about the importance of reproductive justice for this very reason, right? Reproductive justice activists have long asserted that the courts have not been equally effective in protecting the rights of everybody in the country. And in fact, it has been an arm of asserting the lack of personhood for marginalized people in the United States. And the battle is constantly one of trying to get the courts to act in more just ways as it outlines the rights that people have in the United States. And so for me, this is more of us continuing to just try and fight to have courts reflect the personhood of people in the United States that the courts serve to regulate. And there is a very sad and horrific history of courts doing all kinds of or enacting all kinds of violations. And I see this as one more way that we see it playing out. But just like we've done historically, the key is just to keep fighting so that things can improve, and hopefully we'll get to a point where we're not enacting the same kinds of egregious laws that violate people's rights as we have historically. Thank you for this question, Jamie.
Actually, I want to flip it and make it more direct. And I see Professor Anderson just unmuted too, but maybe you can, it's for you as well. The flip of how do we see this affect, thinking about the courts, but how do you, who study people and their understandings of what their rights are and their autonomy, whether it's here in the US or in foreign contexts, see these rulings affecting their sense of self? That's the flip side of this question, not just about what we think about the courts as protecting us. How does this affect how we think of our own selves in this society?
Okay, now you widen the question. Let me, give some thoughts of what I had in mind before, just to echo what Professor Baker and Littlejohn were saying. For me, the example of Latin America, of just like finding themselves in a highly restrictive legal context that was for many decades not changing, and they couldn't put all their hopes in legal strategies, whether it is change the laws through Congress or take their cases to the court, is also to widen the strategies and find non-institutional ways of at least deal with it, as Professor Baker was saying, self-administered abortion, and the resources that we have at this point to just increase access despite the restrictive legislation at this point. I think it's what needs to happen constantly, and of course not abandon the fights in the courts or in Congress, but I think we need to widen the strategies and have parallel strategies. Okay, so kind of fight in all the fronts available.
I wanted to be quiet at the start of this, just so I wasn't like filibustering essentially. But but there's a whole bunch of things that your question kind of is sparking in my head. So it's a little also hard to focus this. But one of the things is that we really need to look beyond courts. That a lot of what has changed is not just Trump appointees on the federal bench. It's really the overall legal resources that conservatives have developed basically over the last 30 years, right? That if we look at this in a bigger spectrum, right? The rights revolution, like the Supreme Court's greatest hits that most people know about in the mid 20th century, there were some conservative courts that were enacting those things, but enacting those favorable rulings, and there are conservative justices favoring those progressive rulings. But what made a difference here is that progressives had the legal resources that conservatives didn't. They had the intellectual resources, they had the lawyers, they had the arguments, and thus they outweighed their opponents in the court, right? And so they could win over conservative justices. Right? A big switch that happened in our political culture, roughly in the, starting in the 1980s, 1990s, was conservatives pivoting from railing against the courts to recognizing that they needed to play within the courts, and thus ramping up their organizational resources to become significant players in the court, right? That's been going on for decades. But what's changed recently, I'd say, is, this is another kind of thing to think about, is religious conservatives, Christian conservatives, have been mobilized by the court also for decades. They have voted on the court, basically. It has been a high salience issue for them. It has not been for Democrats, right? It has not been for progressives. There's kind of this belief that the court was in their side because it was part of this long arch towards justice, right? But one of the things that changed during the Trump administration is the saliency of the court as a voting issue for Democrats, for progressives. So essentially, we had conservatives viewing the court as a political institution and addressing it that way. Now what we're getting are progressives recognizing it more overtly as a political institution and addressing it that way, right? And so this is why we suddenly in this last presidential campaign started hearing about changing the number of justices on the court and so forth, right? It's because it started to become a salient issue for Democratic voters, right? And this, you could also argue, is a problem for the court at its core. The court has power because people view the court as being legitimate. Once people view the court as no longer being legitimate, as being another political branch, just like the legislature, it massively loses its power. And so this is one of the reasons why Chief Justice Roberts, and the reason to pay attention to this fight between Chief Justice Roberts and the rest of the justices, is that Roberts is aware of this. A lot of Roberts's actions can be explained by him trying to preserve the legitimacy of the court. If the court really acts aggressively here, that threatens that perception of legitimacy even more. But I'll stop there.
Thank you all. I want to turn to just a couple of the more specific legal questions. We have one from Joyce Berkman that I understand the Supreme Court can overturn a congressional codification of Roe. Is that not so? We have another that's a question about SB 8 being an end run around incorporation. And a more specific one around the South Dakota governor from Rose Cullon using SB 8 to legislate a ban on self-abortion, self-managed abortions being delivered by mail or online. So tackling those more specific questions. Yes, I see Professor Baker can speak to those pretty quickly.
So 19 states ban mailing abortion pills already, and they're the usual suspects in the Midwest and the South. So that exists, and that's a real barrier as far as doctors living in those states mailing abortion pills. It's not a barrier to aid access mailing them from the Netherlands, I mean, from outside of the country, because they're not worried about criminal prosecution. And those bans are targeted at, doctors and pharmacies. So they're not, only a handful of states explicitly ban people from self-managing abortion. By the way, if you want details on all of this, you can look on the Guttmacher website. They say which states do what. It's a great source for law on abortion rights. The other question was Joyce's, and yes, I mean, the Supreme Court could come up with a reason to overturn the Women's Health Protection Act if it passes. I've always worried that they're going to say that a fetus, has the full constitutional rights, even though the 14th Amendment says only people born or naturalized in the United States are citizens. But they could, a Supreme Court like the one we have, with the people that don't care about following precedent or law, could do whatever they want. I do think that will significantly decrease their legitimacy and fuel things like expanding the court. I popped in the chat box the Ms. Magazine article I wrote in support of expanding the court. Currently, Biden does have a commission looking into this. I say that somewhat skeptically because, it's like the commission where things go to die. But I do think it pops up pretty regularly. People, when they get frustrated with what the court's doing, there's nothing constitutionally that sets the the membership of the court at 9. It was legislatively done. What is constitutional is lifetime membership on the court. So we can't, and I go into this in detail in this article, we can't say, well, let's make them all retire at X age, but without amending the Constitution, which is impossible. But we can change the number of justices through congressional action, because that's, the Constitution says very little about the court. It doesn't say how many justices, and in fact, the number of justices have varied over time. In fact, when Mitch McConnell held up the merit domination for a year, he essentially reduced the number of justices to 8 for almost an entire year. So, you know, it could change. It could expand. I support expanding it to 13 or maybe 15 justices. But, you know, obviously, that's a political heavy lift.
I want to open it up to others. And in the last 5 minutes, if each of you, if there's no responses to the specific legal questions there, if everyone could just give their concluding thoughts that they would like to leave us with. These are personally challenging as well as socially challenging and politically challenging issues. I can guide what are steps to be done.
Okay, so I'll just dive in if nobody else wants to go. I mean, I would just encourage people to get informed and to get active, whether that's calling your representatives and telling them to, you know, support the Women's Health Protection Act, whether it's sending funds to the Texas abortion funds. I mean, they're inundated. Now they have to travel people out of the state to get abortion care. And often disproportionately, it's people that don't have economic resources. And when they go out of state, sometimes their insurance won't cover it. So there's a lot of need. I mean, people can get abortion by traveling out of state, but many people, just the barriers to traveling out of state are enormous. I would encourage people, we have a local abortion fund, the Abortion Rights Fund of Western Massachusetts. I used to be president of it. And we used to talk about, if something like this happened, could we support people flying to Massachusetts to get abortion care? I don't know if they're talking about that now, but I think that we all hands on deck, now or never. I think that we need to push back on this. I think we need to inform everybody that we know. I think we need to write letters to the editor. I think we need to get politically active. I mean, I am a big supporter, obviously, you may know, of abortion pills and getting people informed about abortion pills. They don't know about it. You know, before the law went into effect, Plan C took a truck with illuminated billboards on the side and drove around West Texas telling people about abortion pills and how to get them. I mean, we need to be out in the streets. We need to be working to get folks aware. I mean, I argue in my articles that post-Roe is not going to be like pre-Roe because of the abortion pill, but that's going to need to be informing people about what it is, how to get it, and how to use it safely. It's a very safe drug, but people need to know how to use it. So I think we need to educate ourselves and each other.
I would echo Carrie's point about the key thing right now is to engage in action. And I think sometimes people feel there's a sense of hopelessness, right? And what I've learned from the work that I've done is that assaults on people's reproductive rights and their bodies are long-standing, and the key is just people keep fighting. That can be, as Carrie was mentioning, giving money to abortion funds, helping abortion funds do the work that they do. It can mean giving time to reproductive justice organizations so that you can contribute to agitating for change on the ground. But I think the biggest thing for me is just not to sit and feel like nothing can be done, but to find whatever way that you can do something and to engage in that kind of action so that we can work together to make sure that people have their rights respected and upheld in the United States.
Just very briefly also to echo, the call for activism and coming, from Latin America and researching that region, that is what has worked there. And also just like maybe a specific data about the abortion pill, like in countries in which abortion was criminalized in Latin America, it has been tried in the second trimester and it worked and is safe as long as you're close to a hospital that you can go to, because, because the fetus is more developed, you might need, medical attention because the discharge is larger than in the first trimester. But I plugged in like an article on like the activists that have done it in Latin America. So it is still safe, even though it's still recommended until 10 weeks. So that is something also to read about and have the accurate information of how to use this method safely. Thank you.
Just a quick note, World Health Organization says it's fine to use till 12 weeks. And also, I just want to note, the use of misoprostol was developed in Brazil when women looked at the package and it said, don't use if you're pregnant, could cause miscarriage. So we need to thank women of Brazil for that development.
Some closing thoughts for me. I just want to, again, I kind of always fall back to these larger political contexts. So a couple things that stick out to me. One is how this helps accelerate what we started to see. You can actually roll this back to, again, the Home and Health versus Hellerstedt law, but really an acceleration in the Trump years of, if we look back at abortion politics over time, the real activism in terms of kind of generating legislation and so forth has been on the anti-abortion side. It's been hard for abortion rights activists to think of what kind of legislation they could forward given the constitutional right? Like what kind of activity could they maintain? What kind of legislative momentum and so forth? That started to shift in the Trump years, that in those 4 years, there's a notable spike in quote unquote blue states legislating on behalf of abortion rights activism. And this has taken place on a few different ways. One is kind of going after anti-abortion activism that failed in California. But the more recent versions have been looking ahead at what a post-Roe future might look like and how those states can protect abortion rights within their own borders and then open up their state to surrounding states, right? And so we started to see more of that legislative activity. Another thing that comes up that I think about are the future risks that Republicans face. Republicans and conservatives have long been in a position where they can use abortion as a topic, but not have to worry about succeeding in going too far. And what I mean by this is public opinion has long showed us that the majority of Americans are in favor of keeping abortion legal, that they're against really aggressive regulation and against making abortion access illegal, right? And so Republicans have been in this comfortable position of where they can move, they can use it as a political issue, but that they didn't have to worry about overruling Roe. They're now in the position of where they can really succeed where they haven't before. And that poses political risks potentially for them, given where the majority of the public opinion lies on abortion. So one of the things I'll be looking at in the future is kind of how do Democrats build off of the momentum they have started to develop over the last 4 years, and then how do Republicans deal essentially with the problem of favorable situations for them in terms of enacting legislation and getting favorable court rulings in the future? How do they manage that politically?
Thank you so much to all of our panelists and our participants. We are at time, and I don't want to take any more time from people's busy evenings. I just want to say this was really illuminating. It's a very hard time right now. I hope people are taking care of themselves and their loved ones. We are going to be having more events like this. So this is the first of what we are hoping is going to be a series of talks on SB 8 and reproductive justice and constitutional rights over the course of the semester. The recording of this will be posted on umasscjls.org, the Center for Justice, Law, and Society's website, and stay tuned for announcements about our upcoming events on this topic. Again, thank you to the panelists. I'll be in touch with you later. Good evening.